thanks for joining me today. My name is Kevin Lasaletta, and today we're going to be comparing two constitutions, one from Japan and one from Australia, and specifically around the topic of freedom of expression on tattoos. First off, I'd just like to start by giving a brief introduction of the Constitution of Japan, and also a brief history about tattoos and the role that they played in Japan's history. After that, I'd like to go and dive a little bit deeper into the actual cases and the precedent around Japan's history with tattoos. Though there might not be too many, there definitely are some that are extremely important and helpful for the industry, and also ones that have defined where the industry is going to be heading in the near future. And on the second half, I'd like to go into the Australian perspective of things and start looking at some of the Constitution and how they enforce freedom of expression, and then start diving into the cases as well. After we've looked at both cases from the Japanese and the Australian side, we could then look at the analysis in terms of the ratios or even the tests that derived from each of those cases and see if they would apply to each of the country's standards when applied to certain scenarios. At first glance, the Japanese constitution is very interesting in the way things are ordered out. The first chapter, which is comprised of Article 1 to 8, still speak in a language that reflects Japan's tie to preserving tradition and culture. For example, the language still refers to the emperor, much similar to the way that the queen is still seen as a symbol of the executive branch of government. Moving on to the second chapter, we only have Article 9, which refers to Japan's post-World War II renunciation of war. After World War II, the Japanese constitution came into effect on 3rd of May 1947, and they promised to never again participate in a war. It's not until we get to the third chapter, which comprises of Articles 10 to 40, that we get to what's called the rights and duties of the people. This is commonly interpreted as the equivalent of the human rights portion of Japan's constitution. The two articles we want to focus on are 14 and 21. Article 14 mainly speaks on the issues of equality and anti-discrimination, while Article 21 has a broad scope on freedom of speech and expression. Although our main focus for this analysis is on freedom of expression, it would be difficult not to also talk about equality and anti-discrimination as well, since most of these cases involve some degree of discrimination on tattoos, when tattoos are considered amongst many as a form of expression. But more on that later. Here, we have Article 14 and 21 in their full text. Feel free to pause the video to read it for yourself. So now that we've had a chance to look at freedom of expression in the Japanese constitution, now let's look at the historical and cultural elements of tattoo and why there are still negative stigmas around it today. The history of Japanese tattoos is thought to date back tens and thousands of years. The tattoo of this era seemed to have had decoration and spiritual meaning. After that, from 300 to 600 BC, the tattoo became associated with criminal acts, and a tattoo was used as punishment. From this time on, the tattoo began to have negative connotation. Because criminals used to be punished with tattoos, they've been a symbol of organized crime membership for generations. The stigma against tattoos in Japan is such that even innocent ones are still facing that stigma today. One of the most notorious crime syndicates in the whole world are the Yakuza, or the Japanese mob. Here are some examples of the Yakuza bodysuit, which Yakuza members usually sport. This is quite a significant difference in terms of how tattoos are perceived in Australia. Tattoos are widely common for most younger generations. In general, studies have predicted that 1 in 4 adults from ages 20 to 39 consider tattoos as body art and an ideal way to celebrate coming of age. Tattoos are even becoming increasingly accepted in the workplace. However, there are still limits to this, but that will be a topic of discussion later. Now, let's actually look at some Japanese cases, one in particular that changed the industry forever. In 2015, the tattoo industry in Japan took a major hit when Osaka police raided multiple tattoo studios. The owners and artists of these studios were arrested and fined for working as a tattoo artist without a medical license. That's right. The law in Japan says that to be able to practice tattooing legally, you must be a licensed doctor, due to their strict interpretation of tattooing as being considered a medical procedure. However, this came to be a shock for the artists arrested under this law, since those provisions usually only pertain to regulations aimed at keeping permanent makeup style tattooists in check. However, despite all of this, one man in the industry refused to stand down and pay the fines. Taiki Masuda was one of the many artists whose tattoo studios was raided. He refused to pay those fines and said, "If I pay the fine, then I admit that I was guilty, and everyone will be at risk of getting arrested, so I decided to fight it." Masuda went to trial to argue his case in September 2015, as he was charged with violating the Medical Practitioners Act for tattooing the customers without a medical practitioner's license. He was ordered to pay a fine of 300,000 Japanese yen. He was the only one who refused to pay the fine. He opted instead for a full trial in the Osaka District Court because he said, "Accepting this fine will make all of the tattoo artists in Japan criminals." During this time, Masuda's case raised much awareness on the situations faced by Japanese tattoo artists on a global scale. Nevertheless, on September 27th, the presiding judge still found Masuda guilty of violating the Medical Practitioners Act for tattooing the customers without a medical practitioner's license. But this time, he set his fine at 150,000 yen. Masuda told reporters after the ruling that he planned to appeal the decision. He said, "I do not accept this ruling. I'm practicing art and tattooing is a part of traditional Japanese culture." In that case, Masuda argued that tattooing were a form of art and self-expression, and that denying him the right to operate a tattoo parlor violated Articles 21 of the Constitution. The court rejected this while saying that placing a tattoo on someone else was a dangerous activity not within the bounds of Article 21, although putting a tattoo on yourself was. On the grounds that, with tattoo treatment, medical knowledge and skills are indispensable in order to sufficiently understand the dangers and carry out sufficient judgments and measures. The ruling said that, therefore, unless carried out by a doctor, there is a danger to health and no guarantee of sanitation, making this a medical activity. The following year, in 2018, the case went to the High Court of Japan. This time, Masuda was victorious in his fight for tattoo artists all over Japan. Masuda and his legal team again argued that shutting down his studio and preventing him from doing his work was a direct infringement on his freedom of expression as per Article 21 of the Constitution. The court acquitted Masuda, in addition also held that the tattooing procedure is not relevant to medicine and it does not constitute a medical act controlled under the medical practitioner's law. Masuda was praised on by the global tattoo industry, as many were watching Masuda throughout his battle dauntedly throughout the years, fearing that the iconic Japanese art of tattooing would slowly disappear forever. Now, Masuda is considered a hero and has virtually single-handedly saved the entire tattoo industry in Japan. So now that we know that Masuda's case became case precedent, let's look into the Japanese common law and see some of the legal tests that were done in order to determine how your freedom of expression rights are actually guaranteed. As we've now seen, Article 21 and 14 are both enforced by the Constitution. However, the next thing to compare would be the ICCPR, which both Japan and Australia are members of. Based on research, because freedom of expression is expressly stated in Japan's constitution, reliance on the ICCPR is less prevalent as compared to Australia. The primary authority for Article 21 in Japan's constitution comes from the common law in a Supreme Court of Japan judgment from a case involving the Minister of Education in the state. Here is a test. Freedom of expression under Article 21, Paragraph 1 of the Constitution is not guaranteed without restriction, but it may be restricted for the sake of public welfare to a reasonable and unavoidable necessary extent. Whether or not a restriction on a particular type of freedom is acceptable within such extent should be determined by comparing various factors, including the degree of necessity to restrict the freedom, the content and the nature of the freedom to be restricted, and the manner and level of the specific restriction imposed on the freedom. Now let's apply this test to a controversial topic in Japan regarding tattoos, and that is the banning of customers who have tattoos from Japan's famous hot spring baths. These baths are extremely popular tourist sites. However, the question is it actually legal to ban customers if it potentially infringes their freedom of expression as seen as Masuda's case, or even discriminate as per Article 14? When referring back to our rule, the key elements can be drawn as follows. The degree of necessity to restrict the freedom. There isn't an absolute necessity to restrict someone who has a tattoo from entering the baths. For example, no infliction of direct danger or harm will come about anyone from just having a tattoo. The second element, the content and nature of the freedom to be restricted. Because tattoos are permanently on your body, expression by way of tattoo can't really be something you can just stop if you're going to be bathing. Therefore, restricting expression via tattoo art is an outright restriction from the entire activity in itself. Unless, of course, you want to bathe with your clothes on. And the third element, the manner and level of the specific restriction imposed on the freedom. The restriction completely prohibits anyone with a tattoo from even entering the premises of these hot springs, as signs are outside to forewarn anyone with a tattoo. This degree of restriction directly discriminates anyone with a tattoo. After applying the test, it's obvious to see that this is a violation of the freedom of expression. In fact, lawyers in Japan have recently commented on this topic in agreeance, and in addition, a violation of also Article 14, because of its discriminatory nature on people with tattoos. This was a hot legal topic due to the upcoming Olympics that were supposed to be this year. Now that we finally looked over Japan, let's see what it's like over on Australia's side, and their view on tattoos in general, and how their constitution enforces freedom of expression. As mentioned before, Australia's constitution doesn't expressly state a freedom of expression provision. However, the High Court has said that it is implied. But it operates as a freedom from government restraint rather than a right conferred directly on individuals. For example, in Nationwide News Party Limited and Wills, and also in Australian Capital Television Party Limited and the Commonwealth, the majority of the High Court held that an implied freedom of political communication exists as an incident of the system of representative government established by the Constitution. This was also reaffirmed in Unions New South Wales and New South Wales. That being said, protection of freedom of expression in Australia, also similar to Japan to some degree, relies heavily on the common law and other treaties and conventions. For example, take a look at Article 19 of the ICCPR, which looks at the freedoms of expressions. And also, because we're talking about tattoos here, make note of the fact that they mention art specifically in that provision. There is also a presumption that Parliament is not to intend to limit fundamental rights unless it indicates this intention in clear terms. For example, in the case of Coco and the Queen, the High Court restated this principle as follows: the court should not impute to the legislature an intention to interfere with fundamental rights. Such an intention must be clearly manifested by unmistakable and unambiguous language. This presumption includes fundamental rights recognized by the common law. In Electrolux Home Products Party Limited and Australian Workers Union, it was also held that where there are any inconsistencies or ambiguity in the statute or legislation, Australia should be able to rely upon any treaty or international convention to which Australia is a party of, for example the ICCPR. Now that we've discussed how freedom of expression is enforced in Australia, let's look at how this can apply to tattoos. Although Australia is more on the opposite spectrum in comparison to Japan when it comes to tattoo culture and tolerance, as we've seen, that doesn't mean freedom of expression of tattoos face zero barriers. A topic that can mutually be discussed is the idea of tattoos in the workplace. In Australia, there isn't any specific law preventing employers from banning tattoos in the workplace. However, there are still some exceptions, since Australia can impose freedom of expression rights relied on by other acts and treaties. Banning tattoos on the basis of race, color, sex, age, or a protected attribute may be found to be discrimination or impairing freedom of expression. It is currently a gray area in the Australian law at the moment. For example, the Fair Work Ombudsman, or the FWO, can hold you liable for discrimination if a tattoo is representative of culture or race and your policies demand a ban or full coverage of tattoos. In Victoria, the Equal Opportunity Act prevents discrimination on the basis of physical features. In Victoria, tattoos may have been considered to constitute a physical feature in the case of Jameson v. Benalla Golf Club, Inc. This case is said to be relied on in the future, but for now, there's simply just very little precedent on the topic of freedom of expression on tattoos. Coming back to what we know about Japan, your prospects of getting any sort of office job if you have a tattoo are unfortunately extremely slim. This is because despite having freedom of expression and anti-discrimination expressly stated in their constitution, there are some things in Japan that are just predominantly governed by culture and social norms, things such as tattoos. And this leads into my conclusion for this comparative analysis. I'd like to quote Yasuhiro Okadaira, a Japanese lawyer, when he said that the status of freedom of expression in Japan may be explained by the statement that Japan is politically free, but socially not free. However, the same can now be said to some degree of similarity when it comes to Australia as well. Freedom of expression is more focused on a responsible democratic government than it is on individual rights and freedoms, similar to that in Japan. One thing can be said about both countries' perspective is that tattoos provide a great example of how societal and cultural changes, or lack thereof, are always going to impact the ways in which we interpret and trace the laws that govern us.